of the Diddy Diaries. Over the past couple of days, we've learned that Jayz has been added to a lawsuit that claims that he and Diddy together abused a 13-year-old girl at an after party for the VMAs. Well, Jayz has now responded to that by filing a motion with the judge asking the court to either have the accuser unmasked or to dismiss the entire complaint. So today we're going to dive into Jayz's response and see what he has to say for himself. And to do that, we're going to dive right into this filing. Case number 24CV-07975-AT. Jane Doe plaintiff versus Sean Combs, Daddy's House Recordings, CEOPCO LLC, DBA Combs Global, Combs Enterprise, LLC, Bad Boy Entertainment Holdings Incorporated, Bad Boy Production Holdings Incorporated, Bad Boy Book Holdings Incorporated, Bad Boy Records LLC, Bad Boy Entertainment LLC, Bad Boy Productions LLC, Organizational Does 1 through 10, Individual Does 1 through 10, and Sean Carter, the defendants. Defendant Sean Carter's motion to deny plaintiff's request to proceed anonymously pursuant to Fed R. Civ P10A or to dismiss the complaint pursuant to Fed R. Civ P12B1. For months, an extortionate campaign has been targeting this named defendant under the cover of darkness. That campaign was cynical and calculated to force payment of an exorbitant amount of money. Defendant would have to pay X millions of dollars, irrespective of the truth, or else, when defendant refused to pay and instead took measures to establish his innocence, this unnamed plaintiff and her self-promoting counsel, whose name has been splashed across headlines and press conferences under the auspices of representing her, went to extraordinary lengths to shut down fair defense. But those efforts, too, failed. Now, at least, the false, unfounded allegations that underlie this campaign of extortion are having judicial light shined on them, except that this plaintiff is bringing them as a doe, who would continue to hide under the cover of darkness, because that tactic is inconsistent with a genuine effort to determine the truth or falsity of these allegations, as opposed to an effort to procure a quick extortionate settlement. Defendant is respectfully seeking either dismissal of the allegations or disclosure of the plaintiff's identity. Fair is fair. It's not consistent with justice, fairness, or the rules of governing federal proceedings for the plaintiff and her counsel to smear defendant's good name in the ways that are calculated to feed media coverage and thus inflict maximum public relations damage, while the core fact of plaintiff's identity, revelation of which stands to discredit her entire case, remains wholly hidden from view. Whereas doe status is reserved for truly extraordinary cases and predicated upon extraordinary justification, here a multitude of powerful considerations cut precisely the opposite direction, as other judges of this court have ruled in cases involving the same circumstances. Defendant Sean Carter has built an impeccable reputation. He's never been accused of, let alone engaged in, any sexual misconduct, until today, when plaintiff, in an amended complaint filed by attorney Anthony Busby, has leveled baseless allegations and accused Mr. Carter of despicable acts while hiding behind the pseudonym Jane Doe. These claims are not just about justice for victims, nor are they giving victims of sexual violence a voice. Instead, they are merely the next chapter in attorney Busby's sprawling extortion saga, a saga whose aim is base and measured in dollars. Busby has devoted himself to the business of extracting large settlements from celebrities, high net worth individuals, and businesses with any public ties to Sean Combs, following his indictment for sex crimes in September of 2024. References to justice or sunlight serve only as window dressing. Make no mistake, this case is about retaliating against the rare target who would not pay. Attorney Busby has a history of targeting celebrities by making false allegations of misconduct, and Mr. Carter sought to expose Attorney Busby's latest extortion scheme in California's lawsuit on November 18, 2024. After receiving a demand letter from Attorney Busby, Exhibit 1, Extortion Complaint. At the time, Attorney Busby knew who Mr. Carter was, even as Mr. Carter remained in the dark, as he does today, about the identity of Mr. Busby's client. Plaintiff and Attorney Busby now bring these claims against Mr. Carter in a clear act of retaliation, as the complaint admits on its face. While Mr. Carter was being extorted, he cannot speak out without revealing his identity and the heinous allegations made against him, which are patently false. That would be playing into Attorney Busby's game and the leverage he is wielding. The upshot would be highly sensational and equally false, allegations being broadcast across social media and the press, thereby maximizing the pressure exerted against extortion targets to satisfy his monetary demands, irrespective of the truth. Because Mr. Carter called upon the courts rather than paying, he has now been sued. So be it. One way or another, Mr. Carter is entitled and positioned to exonerate himself through the legal process. In this case, he will vigorously defend himself and expose the truth, that these allegations in the complaint are false. But disclosure of plaintiff's identity is among the most essential basic tools that can and should be enabled to Mr. Carter to vindicate himself. Mr. Carter should not have to defend himself in the brightest of spotlights against an accuser who hides in complete darkness, while leveling allegations that describe the purported acts occurring in the plain sight of witnesses who could refute the plaintiff's claims if only her identity was revealed. Amended Complaint 58 through 60. In the American judicial system, lawsuits are public by their nature and their design. The public is meant to know the facts involved and the identities of the parties. Indeed, federal law requires that all parties litigate using their true names. Parties are exempted from this mandate only in exceptional cases, where, for instance, allowing the party to proceed anonymously will protect him or her from physical violence, deportation, imprisonment, or severe harassment. Here, a plaintiff is chosen to sue Mr. Carter anonymously, using the pseudonym Jane Doe, yet has not alleged any facts that would allow her to sidestep the federal mandate requiring that all parties must litigate using their true names. Indeed, plaintiff's allegations exhibit none of the special circumstances necessary to allow her to litigate anonymously. To the contrary, her factually incredible allegations indicate that, unlike in many cases of alleged sexual misconduct, she has already been exposed in plain sight to countless witnesses whose truthful accounts would be helpful and properly informed by specification of her identity. Notably, she has not claimed severe harassment, threats of violence, or any ongoing interaction with Mr. Carter beyond communication through her attorney. Nor has plaintiff even submitted an affidavit alleging these types of special circumstances. Instead, she relies solely on a self-serving declaration from Attorney Busby. Attorney Busby's affidavit does not indicate how an attorney from Texas is competent to testify as to the mental state of plaintiff, let alone how he has the personal knowledge of what happened to her in New York to supposedly cause that mental state. The declaration does little more than parrot Busby's own motivations and a legal standard. That is, it does not provide any actual facts indicating that plaintiff is in need of extraordinary protection. Suffice it to say that attorney proffered innuendo and generic accusations do not suffice to justify why Mr. Carter and the American public should be denied access to plaintiff's identity in this highly public litigation. If anything, this case presents an extraordinary need to follow the ordinary rules of litigation and have both parties proceed under their actual names. Attorney Busby, for months, has taken to traditional and social media to describe how he planned to target celebrities in connection with these allegations, and he has now issued multiple social media posts about this action. Traditional media sources have somehow been reporting, with Busby's express endorsement on social media, that Mr. Carter is the target of Busby's allegations. Thus, the plaintiff, through her counsel, has acted quite unlike a party who wants to minimize the amount of public attention on this matter. Instead, Busby has attempted to leverage public scrutiny to taint the potential jury pool and put pressure on Mr. Carter to settle this meritless case. In those circumstances, it would be extraordinarily unfair if the plaintiff could continue to hide behind the shield of anonymity while leveraging public interest in this case strategically to pressure the defendant. Furthermore, the allegations here describe serious criminal violations. It is fundamental in the American legal tradition that a person accused of such actions has the right to know the identity of the accuser and confront that person in open court. Moreover, the amended complaint itself makes clear what this is all about. Not justice, but a quick and large settlement against a celebrity. The amended complaint on its face alleges that Busby chose to sue Mr. Carter because he fought back against Busby's extortionate tactics. As Busby subsequently tweeted, Mr. Carter's conduct in defending himself has had the opposite impact because, in Busby words, plaintiff is emboldened. And although the complaint alleges that another celebrity, Celebrity B, was also involved in the alleged actions, it does not reveal her identity. No doubt because Busby seeks to leverage his public allegations against Mr. Carter to extract a settlement from her. None of this is consistent with the genuine effort to seek justice and truth. This court should not allow this strategic abuse of the judicial system to continue. Mr. Carter deserves to know the identity of the person who is effectively accusing him in sensationalized publicity-hunting fashion of criminal conduct, demanding massive financial compensation, and tarnishing a reputation earned over decades. This court has recognized that nearly identical claims brought by other plaintiffs represented by Attorney Busby do not meet the criteria to proceed anonymously. Here, the balance of the equities afford all the more reason why the plaintiff should be proceeding under her true name, if she wishes to proceed at all. Our action makes no specific reference to special circumstances unique to plaintiff's case. Instead, it only makes broad and generalized assertions about Attorney Busby's other clients, Busby Declaration at 5. Strikingly, an overwhelming number of these clients, likely in excess of 80%, have stated to me or attorneys at my firm during their intake process that Mr. Combs made threats of violence against them or against clients' family members if the client disclosed to anyone the facts of the sexual assaults or other acts of Mr. Combs of which they were a victim. In at least 2 cases filed by Attorney Busby with his declaration, other courts in this district have already denied his baseless motion to proceed anonymously for failure to meet the burden to show that each plaintiff was entitled to the exceptional remedy of anonymity. Exhibit number 2, October 30th, 2024. The court concludes that the balance of interest at stake weighs strongly against granting plaintiff's motion, where a plaintiff who is an adult has now decided to file a lawsuit in which she accuses a famous person of engaging in heinous conduct approximately 20 years ago, and defendants have a right to defend themselves, including by investigating plaintiff, and the people have a right to know who's using their court. Exhibit 3, February 29th, 2024 order. While the court does not take plaintiff's concerns lightly, the court cannot rely on generalized, uncorroborated claims that disclosure would harm plaintiff to justify her anonymity. Those cases concern Combs, who is under indictment and detained following a raft of criminal and civil allegations against him. But plaintiff has now sought to sully the reputation of Mr. Carter, who has never been accused of misconduct in his 37 adult years. Plaintiff has not come close to meeting her burden here and the balance of equities that she litigate under her true name. There is every indication that this lawsuit is not truly about plaintiff, but about Attorney Busby's larger, unsavory agenda. Despite plaintiff's request to proceed anonymously, plaintiff's counsel is doing everything to draw widespread attention to her. The same day that the amended complaint was filed, naming Mr. Carter, Attorney Busby posted on Instagram and Twitter, prominently featuring himself, addressing the amended complaint, and making clear this is not about his clients, but about his personal spat with Mr. Carter. Exhibit 4, December 8th, 2024. Instagram post, Exhibit 5, December 8th, 2024, Twitter post. What is more, Attorney Busby has made numerous social media posts and statements to the media regarding his representation of individuals with allegations against Sean Combs, including that he would target other unnamed celebrities. These statements began a couple weeks after Mr. Combs' indictment and continued after plaintiff, through Attorney Busby, sent Mr. Carter unfounded demand letters in November 2024, falsely accusing him of rape. These baseless claims, unsupported by evidence, are nothing more than calculated efforts to strong-arm Mr. Carter into submission. When Mr. Carter proved unwilling to pay, Attorney Busby escalated his tactics and schemed further, threatening to conjure additional false accusations and manufacture a parade of fictitious additional victims to emerge and further damage Mr. Carter's reputation. To coerce Mr. Carter into compliance, plaintiff and Attorney Busby imposed an arbitrary deadline in their extortionate demand letter, warning Mr. Carter that they would take a different course if he did not agree to a confidential mediation to resolve this delicate and important matter. Without even waiting for the deadline provided by the extortionate demand letter to pass, Attorney Busby posted on social media that he intended to file a lawsuit naming Mr. Carter and attaching the extortionate demand letter to punish Mr. Carter for seeking redress from a court. All along, Mr. Carter refused to bow to attorney Busby's scheme. Faced with the choice to pay either an exorbitant sum to silence plaintiff's wild false allegations of sexual assault, risking irreparable harm to his reputation, family and career, and livelihood, or face a barrage of baseless lawsuits and financial ruin, Mr. Carter stood his ground. On November 18, 2024, Mr. Carter filed a complaint against attorney Busby and his law firm for his extortionate conduct. In retaliation, plaintiff and attorney Busby filed the amended complaint. They did so, however, only followed a failed attempt by attorney Busby to obtain a restraining order against Mr. Carter's counsel. Attorney Busby is only bringing these false claims against Mr. Carter in retaliation for his failure to respond to her pre-litigation demand letter. ECF 29 amended complaint. Plaintiff goes so far as to accuse Mr. Carter of filing an utterly frivolous lawsuit, orchestrating a conspiracy of harassment, bullying, and intimidation against plaintiff's lawyers, their families, employees, and former associates in an attempt to silence plaintiff from naming Jayz. Rather than citing a desire for compensation for any actual harm suffered, because there was none, plaintiff, through her counsel, apparently chose to file this amendment as a result of the egregious conduct perpetrated by Carter against attorney Busby, quite different from the plaintiff. These tactics are designed to silence the other extortion victims who, like Mr. Carter, have been targeted by attorney Busby, not based on their perceived culpability, but the depth of their pockets. Attorney Busby's tactics send a clear message. Any individual who resists extortionate demands will face public retaliation through highly publicized lawsuits. This strategy is designed to silence other victims of attorney Busby's extortion while creating media spectacles to amplify unfounded claims and maximize monetary recoveries outside of court. That this plaintiff is suing only now, after attorney Busby has been left stinging from personal rebukes and defeats, supplies positive proof of how he elevates his own interests above those of his clients. Needless to say, this proceeding should not be driven by attorney Busby's agenda or interests. It's about finding the facts, applying the law, and fairly adjudicating what is the actual truth. Mr. Carter is now entitled to defend himself against these allegations with the benefit of all the protections and mechanisms available to defendants. To be sure, attorney Busby's game has been to prevent Mr. Carter from defending himself while punching below the belt. Today that game is at an end, and Mr. Carter's defense has begun, starting with plaintiff's unmasking. Procedural history. On November 6, 2024, before Mr. Carter was named, the court provisionally granted the plaintiff's motion to proceed under a pseudonym in this case. At that time, the only named individual was Mr. Combs, who was indicted and who had a flood of allegations leveled against him by a myriad of plaintiffs at the same time. In that order, the court clarified that, at the time it was entered, the balance of these interests may shift as this matter proceeds, and defendants deserve to be heard on the issue. On December 8, 2024, plaintiff's counsel filed an amended complaint naming Mr. Carter an upstanding public figure who has never been accused of anything like this in his life. By plaintiff's own admission, Mr. Carter was named solely because Mr. Carter refused to cede to plaintiff's counsel's extortionate demands. Amended complaint at 32. Plaintiff's counsel knows he cannot continue to proceed with these lawsuits anonymously. Indeed, another judge in this very courthouse, considering precisely the same circumstances presented by plaintiff here, declined to permit that plaintiff to proceed anonymously. See McCrary v. Combs, 24-CV-8054 MKV at ECF 17, SDNY, October 30th, 2024. Mr. Carter now brings this motion because these circumstances have changed. What the amended complaint at issue no longer reflects the interests of the plaintiff. It is now a vehicle serving the singular agenda of attorney Busby. Lest there be any doubt, one only need to look to social media posts attorney Busby made concurrent with the filing. It features no image or symbolism related to any purported victim of sexual assault. It features only attorney Busby himself. Plaintiff's amended complaint should be dismissed, and the motion to proceed anonymously denied as moot. In the alternative, the court should require plaintiff to identify herself so that Mr. Carter can adequately defend himself against these baseless and spurious allegations. The legal standard. A putative plaintiff must establish subject matter jurisdiction to proceed before the court, and thus the court must know who is seeking redress. See Fed R. Civ P. 12b1. And Rule 10a of the Federal Rules of Civil Procedure thus provides that the title of the complaint must name all parties, Fed R. Civ P. 10a. See also Publicola v. Lamenzo, 54F, 4th, 108, 112, 2nd Circuit, 2022, United States v. Pilcher, 950, F.3d, 3945, 2nd Circuit, 2020. This rule, which cannot be set aside lightly, serves the vital purpose of facilitating public scrutiny of judicial proceedings. Seal Plaintiff v. Seal Plaintiff, 537 F.3d, 185, 188, and 89, 2nd Circuit, 2008. As the Second Circuit has explained, the people have a right to know who is using their courts. ID quoting Doe v. Blue Cross and Blue Shield United, 112 F.3d, 869, 872, 7th Circuit, 1997. Indeed, this right is supported by the First Amendment. Doe v. Skyline Automobiles Incorporated, 375 F. SUPP 3D 401, 404, SDNY 2019. Quoting Doe v. Delta Airlines Incorporated, 310 FRD 222, 224 SDNY 2015. A district court can grant an exception to this rule, but only in exceptional circumstances where the plaintiff has a substantial privacy interest that outweighs the customary and constitutionally embedded presumption of openness in judicial proceedings, and the court must also consider the interests of the opposing party when making this determination. The Second Circuit has enumerated a non-exhaustive list of factors to determine whether a plaintiff's interest in anonymity outweighs the interest of both the public and the defendant. 1. Whether the litigation involves matters that are highly sensitive and of a personal nature. 2. Whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously, or even, more critically, to an innocent non-party. Whether identification presents other harms and the likely severity of those harms, including whether the injury litigated against would be incurred as a result of the disclosure of the plaintiff's identity. Whether the plaintiff is particularly vulnerable to the possible harms of disclosure, particularly in light of her age. Whether the suit is challenging the actions of the government or that of private parties. Whether the defendant is prejudiced by allowing the plaintiff to press her claims anonymously, whether the nature of that prejudice, if any, differs at any particular stage of the litigation, and whether any prejudice can be mitigated by the district court. Whether the plaintiff's identity has thus far been kept confidential. Whether the public's interest in the litigation is furthered by requiring the plaintiff to disclose her identity. Whether, because of the purely legal nature of the issues presented or otherwise, there is an atypically weak public interest in knowing the litigants' identities. And 10. Whether there are any alternative mechanisms for protecting the confidentiality of the plaintiff. A district court is not required to discuss every factor or use particular formulation provided that plaintiff to reveal her identity or dismiss her suit against Mr. Carter. Highly sensitive personal allegations. Plaintiff's allegations, as pleaded, are highly sensitive and personal in that they describe a sexual assault, to be sure, one that Mr. Carter was not involved in. However, allegations of sexual assault by themselves are not sufficient to entitle a plaintiff to proceed under a pseudonym. Courts in this district have denied motions to proceed under a pseudonym despite concluding that the plaintiff's allegations were highly sensitive and personal. Risk of harm to plaintiff or third parties. The second factor is whether identification poses a risk of retaliatory physical or mental harm to the plaintiffs, or even more critically, to innocent non-parties. The plaintiff offers no evidence of any actual risk of harm to her whatsoever. Instead, Attorney Busby makes the speculative and conclusory allegations that appear to pertain primarily to other clients of her counsel, not to her. Courts have routinely rejected attempts by litigants to shoehorn themselves into the narrow exception to the names disclosed rule through such conclusory second-hand declarations. Mr. Carter denies the allegations, has no idea who plaintiff is or who she could possibly be, and thus he has no contact with plaintiff for the approximate 20 years since the alleged incident, which, even if it occurred, did not involve Mr. Carter, and there is no allegation of any threats to plaintiff in the complaint. Mr. Carter is a well-regarded public figure represented by competent counsel who, in contrast to plaintiff's counsel, intend to litigate this case through the court system rather than social media. In any event, counsel has not identified any present threat of physical harm to plaintiff from anyone. Plaintiff's counsel stresses that other alleged victims he represents have stated that Mr. Combs made threats of violence against them or against client's family members if the client disclosed to anyone the facts of the sexual assault. But there is certainly no allegation that Carter ever threatened to harm plaintiff, nor could he, as he has no idea who she is. Plaintiff's counsel asserts, without offering any evidence, that plaintiff would certainly experience mental harm if she is forced to reveal her identity to the public. See memorandum at 5. In this context, public humiliation is not enough. Leonelli, 2022 WL 2003 635 at 3, quoting Doe versus Hochul, 2022 WL 836990 at 7. EDNY, March 12, 2022. See RAP 573, SUPP 3D at 528, and N38. Abdel Razek vs. Alvarez vs. and Marcel, Incorporated, 2015 WL 7017431 at 3 SDNY, November 12, 2015. Nor is it sufficient for plaintiff to put forth a generalized argument that revealing the identity of a victim of sexual assault would further victimize her. Skyline Automobiles Incorporated, 375F.SUPP 3D at 406. Accepting such an argument would be to hold that nearly any plaintiff alleging sexual assault could proceed anonymously, which simply is not the law in this circuit. Rather, courts require direct evidence linking disclosure of plaintiff's name to a specific injury. Doe versus Gong, C. Fa Kai, Incorporated, 2019, WL 3034793 at 2. SDNY, July 10th, 2019. One court in this circuit allowed a plaintiff to proceed anonymously, where she submitted evidence from a medical professional who predicted that requiring disclosure of her name would cause psychological and emotional pain so intense that it would threaten her ability, her safety, and even her life. Doe v. Smith, 105F.SUPP 2D 4043 EDNY 1999. Even where such medical evidence is present, other factors may still tip the balance against permitting a plaintiff to proceed anonymously. See RAP 537F SUPP 3D at 529. Regardless of what types of direct evidence might support such a finding, it's well established that counsel's conclusory statements and speculation about mental harm to plaintiff is insufficient. Skyline Automobiles Incorporated, 375 F.SUPP 3D at 406. See Bronca USA Incorporated, 2022 WL 2713543 at 4. Doe versus Frayden, 2021 WL 499 1731 at 2. SDNY, October 27th, 2021. Ruling that plaintiff's own affidavit about her risk of mental harm without more was insufficient. Indeed, plaintiff's own brief makes clear that the courts require evidence. See PL Memorandum at 4, citing Smith and Connecticut State Court, a case that acknowledged that plaintiff in those cases submitted evidence from a doctor and therapist respectively. But as discussed above, there's no such evidence, just the motion say so. See Skyline Automobiles 375 F.SUPP 3D at 406. Rejecting a request for anonymity based exclusively on conclusory statements and speculation. Plaintiff's counsel has failed to provide any evidence, no statement from a mental health professional, no affidavit from plaintiff herself, nor any corroborating proof to support the bare claim that disclosing plaintiff's identity would harm her mental health. Counsel's unsupported assertions are insufficient. Plaintiff must offer the court more than just mere speculation to justify proceeding anonymously. Skyline Automobiles Incorporated, 375F.SUPP 3D at 405. While Mr. Carter is a public figure, this does not outweigh his and the public right to the customary and constitutionally embedded presumption of openness in judicial proceedings. Sealed Plaintiff 537 F.3D at 189. Plaintiff has chosen to bring this lawsuit, leveling serious charges, and as such, she has put her credibility in issue. Shakur 164 FRD at 361. Moreover, her counsel has expended considerable time and energy publicizing this case, dragging Mr. Carter and countless other public figures into baseless litigation for his own gain. Indeed, when Mr. Carter refused to succumb to the outrageous demands that Mr. Carter pay up, Attorney Busby immediately escalated. Within minutes of filing the amended complaint naming Mr. Carter, he posted about it on social media, prominently featuring himself, weaponizing the judicial process to amplify his unfounded accusations. The motivation of naming Mr. Carter here could not be more clear. It has nothing to do with justice for victims. It's all about Attorney Busby. As plaintiff's counsel has repeatedly claimed, sunlight is the best disinfectant. Mr. Carter is entitled to investigate the plaintiff's background and challenge her allegations and her credibility in order to defend himself against these false accusations. Moreover, media outlets have a constitutional right to publish stories about this case. See New York Civil Liberties Union versus New York City Transit Authority, 684 F.3D 286, 298 2nd Circuit, 2012. Further, many individuals who have made serious allegations against Combs have filed lawsuits in this district in their own names. See Ventura versus Combs, see Jones versus Combs, McKinney versus Combs, English versus Combs, Richard versus Combs, Graves versus Combs, McCrary versus Combs. All of these lawsuits involve sensitive allegations that could expose plaintiff to scrutiny and embarrassment. Plaintiff has not shown that she is entitled to the exceptional remedy of anonymity where these are not. Rap 537 F.SUPP 3D 527 and 528. Plaintiff does not contend that disclosure of her identity poses a risk of harm to any innocent non-party, so this factor favors revelation of the plaintiff's identity. Other harm. Plaintiff does not argue that she faces other severe harms for which second factor does not account. Accordingly, the court finds that plaintiff's assertions of potential harms are speculative, unsupported by evidence, and insufficient to justify anonymity in this case. Allegations by plaintiff's counsel that routine investigative activities related to pending trial claims in other fora are harassing should be disregarded. Plaintiff's counsel tried to prevent Quinn Emanuel from investigating Mr. Carter's claims of extortion by trying to enjoin the firm from contacting anyone related to the Busby law firm. That request was denied 2 days before the amended complaint was filed in this case, further evidencing Attorney Busby's retaliatory behavior. Plaintiffs are ways against anonymity. Plaintiff is not especially vulnerable, particularly in light of her age. Seal Plaintiff 537 F.3D at 190. Plaintiff is an adult now, 37 years old, and she has not identified any reason for the court to treat her as more vulnerable than the great run of adult plaintiffs who bring allegations of sexual assault in their own names. Thus, the fourth factor weighs against plaintiff's request to proceed under a pseudonym. See Towns 2020 WL 2395159 at 5. All right, we're going to wrap up right here, and in the next episode, we're going to finish this bad boy off. All of the information that goes with this episode can be found in the description box. .SUPP 3D at 532. Mr. Carter and all of the other defendants are private parties. As such, Factor 5 weighs against plaintiff. Prejudice to defendants weighs against anonymity. The six-seal plaintiff factor is whether the defendant is prejudiced by allowing the plaintiff to press her claim anonymously. Seal plaintiff 537 F.3D at 190. Relevant to the inquiry is whether defendant would experience difficulties in conducting discovery, the reputational damage, and the fundamental fairness of proceeding anonymously. Rap 537 F.SUPP 3D at 531, quoting Towns 2020 WL 2395159 at 5. Mr. Carter would be prejudiced in all of these respects. Counsel's assertion that Mr. Carter or other defendants need not know plaintiff's identity to file an answer and conduct discovery strain credulity. Plaintiff asserts that defendants will still have the right to depose or confer with any and all witnesses. PL Memorandum at 7. Clearly, Mr. Carter needs to know plaintiff's identity to depose her and to prepare to depose her. That much is given. But if Mr. Carter does not know who is falsely accusing him, he cannot thoroughly investigate her allegations and her background and otherwise prepare a defense to her claims. See Rap 537 F.SUPP 3D at 531. Plaintiff is bringing a lawsuit about an incident that allegedly occurred more than 24 years ago. which may be difficult to defend given the passage of time, even with information about plaintiff's identity hamstringing Mr. Carter by preventing him from even knowing where to begin his investigation. That cannot be permitted. See CTS Corporation v. Wahlberger, 573 U.S. 1-8-2014, discussing the need to prevent injustice in connection with revival claims that have been allowed to slumber until evidence has been lost, memories have faded, and witnesses have disappeared. Plaintiff's counsel confidentially disclosing plaintiff's name to defense counsel would not obviate the potential prejudice. Highly publicized cases can cause unknown witnesses to surface. Rap 537F.SUPP 3D at 531. However, if plaintiff's name is kept from the public, information about only one side may thus come to light. Quoting Doe v. Del Rio, 241 FRD 154-159 SDNY 2006. In particular, persons with information about plaintiff or allegations that would be helpful to the defense likely would have no way of knowing to come forward. This asymmetry between parties not only would prejudice defendants, but would hinder the judicial interest in accurate fact-finding and fair adjudication. Quoting Doe v. Weinstein, 484, F.SUPP 3D 9098, SDNY 2020. This is especially true for a 2-decade-old case where Mr. Carter is already prejudiced and at a disadvantage to defend himself and find witnesses and evidence to disprove the false allegations. Indeed, the potential prejudice to Mr. Carter with respect to discovery is inseparable from the potential prejudice to his reputation and fundamental fairness. Plaintiff alleges that named and yet unnamed individuals and entities engaged in or facilitated heinous conduct with Mr. Combs or were complicit in the same. If damaging information about only one side is aired through the litigation, Mr. Carter cannot mitigate the damage to his reputation from being included in these false claims. Thus, courts in this circuit have long stressed that the fundamental unfairness of allowing a plaintiff to make her accusations from behind a cloak of anonymity. Delta Airlines Incorporated 310 FRD at 225, quoting Shakur, 164 FRD at 361. This factor accordingly weighs against anonymity. Confidentiality of plaintiff's identity to date. The 7-seal plaintiff factor is whether the plaintiff's identity has thus far been kept confidential. Seal plaintiff 537F.3D at 190. If confidentiality has not been maintained, courts typically reject a motion to proceed under a pseudonym. CEG Skyline Automobiles Incorporated 375 F.SUPP 3D at 407. RAP 537 F.SUPP 3D at 529. Plaintiff's counsel represents that plaintiff has not spoken publicly about the incidents she alleges in the complaint. Busby Declaration at 7. Plaintiff may have spoken privately to an unknown number of people without having ever received assurances of confidentiality from any of them. RAP 537F, SUPP 3D at 529. Plaintiff's counsel has broadcast the cases against Combs widely in the news media, where he has threatened to name countless other celebrities and high-profile individuals as defendants, and within minutes of filing the amended complaint in this case, he has already blasted it across social media. Quite clearly, the confidentiality of this proceeding is not paramount to plaintiff or her counsel acting on her behalf. Plaintiff and her counsel cannot be permitted to wage a public smear campaign against Mr. Carter and his counsel while hiding behind a veil of anonymity. The public interest weighs against anonymity. The ACO plaintiff factor is whether the public's interest in the litigation is furthered by requiring the plaintiff to disclose her identity. Seal plaintiff 537 F.3D at 190. The ninth factor is whether, because of the purely legal nature of the issues presented, there is an atypically weak public interest in knowing the litigants' identities. These factors clearly weigh against granting plaintiff's motion to proceed under a pseudonym. As a rule, lawsuits are public events, and the public has a legitimate interest in knowing the facts involved in them. Among those facts is the identity of the parties. Shakur, 164 FRD at 361. There is undeniable public interest in these allegations against Mr. Carter and the identities of his accuser. This is not a case that involves abstract challenges to public policies, but rather particular actions and incidents. New Jersey Media Group Incorporated, First Doe number 1 through 5, 2012, WL 589-9331 at 8, SDNY November 26, 2012. Thus, open proceedings benefit the public as well as the parties. Indeed, this is the kind of case that furthers the public's interest in enforcing legal and social norms. See also Skyline Automobiles Incorporated 375, F.SUPP 3D at 408. Plaintiff contends that the public interest favors granting her motion to proceed under a pseudonym so that victims of sexual assault will not be deterred from vindicating their rights. However, as noted above, a number of other alleged victims have already sued Combs in their own names in this district. As such, those plaintiffs obviously were not deterred by the long line of previous cases in which courts in this district have rejected motions to proceed under a pseudonym brought by alleged victims of sexual assault who have made the same arguments about the public interest and possibility of deterrence. See Shakur 164 FRD at 362, Weinstein 484 F.SUPP 3D at 98, Rapp 537 F.SUPP 3D at 532 and 33. Moreover, there is a critical public interest in allowing the accused publicly to confront their accuser. Bronca USA Incorporated 2020 WL 2713543 at 2. If notwithstanding that a number of the other alleged victims have already sued in their own names, other potential plaintiffs are deterred by this decision from filing their own lawsuits. That is an unfortunate result of the fundamental countervailing interests that generally require a plaintiff and others like her to seek vindication of their rights publicly. Shakur 164 FRD at 362, see Pilcher 950 F.3D at 45. The availability of alternative mechanisms weigh against anonymity. The final sealed plaintiff factor is whether any alternative mechanisms, short of proceeding under a pseudonym, could protect plaintiff's interest in confidentiality. Sealed plaintiff 537 F.3D at 190. Plaintiff can seek less drastic remedies than blanket anonymity, such as redactions, to protect particularly sensitive information or a protective order, though she has not yet done so. See E.G. Doe versus Berg. Thus, Factor 10 weighs against plaintiff's motion. The balance of interest weighs against anonymity. The balance of interest at stake weighs strongly against granting plaintiff's motion to proceed under a pseudonym. The fundamental question is whether plaintiff has a substantial privacy interest that outweighs the customary and constitutionally embedded presumption of openness in judicial proceedings. Plaintiff, who is an adult, has now decided to file a lawsuit in which he accuses Mr. Carter of engaging in heinous conduct more than 20 years ago. And she has chosen to have her counsel loudly try this case in the media and the court of public opinion. Moreover, there is no evidence of exceptional circumstances that in and of themselves justify overriding the constitutional presumption of openness. Mr. Carter has a right to defend himself, including by investigating plaintiff, and the people have a right to know who is using their courts. CIG Pilcher 950 F.3D at 42. Plaintiff has not carried her burden to show that she is entitled to any exceptional remedy here. 2. In the alternative, the court should dismiss the complaint under Federal Rule of Civil Procedure 12b-1. A complaint that fails to adhere to Rule 10a is subject to dismissal under Rule 12b-1 for lack of subject matter jurisdiction due to the plaintiff's lack of standing. As detailed above, plaintiff's motion fails to meet the stringent requirements for narrow exception to the rules. Numerous courts have rejected similarly vague and unsupported assertions at the pleading stage. Plaintiff has provided no evidence, no affidavit, declaration, or specific factual support to establish the kind of severe harm necessary to justify having a pseudonym. Her vague assertions for potential harm of the stringent requirements established by the Second Circuit and other federal courts. The lack of specificity in plaintiff's motion, combined with her counsel's public actions, drawing attention to this litigation, undermines any claim that anonymity is necessary to protect her privacy or her safety. Moreover, plaintiff's failure to comply with Rule 10a deprives the court of subject matter jurisdiction. Federal courts lack jurisdiction over unnamed parties because such cases are not properly commenced. Without plaintiff's true identity, there is no justiciable controversy, and the court cannot adjudicate the case. See Doe v. Unum Life Insurance Company v. America, 164F.SUPP, 3D 1140-1142. Plaintiff makes no effort to explain how litigation will work in practice without Mr. Carter knowing who plaintiff is. Accordingly, because plaintiff fails to meet the requirements for having a pseudonym and has not properly commenced this action, the court should deny her motion and dismiss the amended complaint under Rule 12b-1. Conclusion. Mr. Carter would request that this court revisit its provisional order permitting plaintiff to proceed anonymously and require the plaintiff to refile her complaint with her true name. To the extent she fails to do so, Mr. Carter would request that the court then dismiss the complaint for failing to satisfy Fed.R. Civ P10A and for therefore failing to establish subject matter jurisdiction pursuant to Rule 12b-1. This document was dated December 9th, 2024, and it was signed by Alex Spiro at Quinn Emanuel.